So typically today we are really going to discuss about what the landscape of insurance claims in India is. And we all are familiar to the very idea of insurance, and it's perhaps known to everybody because at some stage in life we all have come across something, maybe for a car or for your individual mediclaim insurance, or for insuring something as simple as even flight tickets now, or your flight journeys, which automatically gets built in while you purchase some tickets or do something of that kind. So that idea is very familiar to all. The concept, however, when applied to the legal framework, comes with its own set of complexities. And these set of complexities are, of course, something which is popular in any litigation, something which is popular with a building related litigation, or something which is popular with any sort of litigation. However, what is required to be seen is that there are some two broad outlines. We'll make an attempt to really, I mean, not look at the various types or what really those different types of insurance really have to offer, but we'll make an attempt to really see what are the two outline concepts under which insurance falls, and how are these concepts taken up in the legal framework. So first, of course, is your very basic principle of what you have is, as your you pay the premium, you are given an insurance cover by the company, and thereafter in return you insure a particular product. That product could be your mobile phone, that product could be your vehicle, that product could be your premises, which is very commonly there in commercial policies. Say you are running a business house and you want to insure your premises for a typical peril like fire or flood or something similar to that. And thereafter you want to take care that, look, you are having assets worth say 5 crore rupees, you have stock worth another 5 crore rupees, and thereafter you want to take insurance. So how does that typically work? You are required to pay premium, and you are the one paying premium, and you are the one, or your company or your firm, etc., whoever's name the policy stands, is somebody who's getting insured in return. The other set is something peculiar, which is your third party liability claims. So what happens in third party liability claims is the beneficiary, the end beneficiary, is not somebody who's really paying the premium. For instance, you are having your motor vehicle car, you take a third party cover, and unfortunately there is an accident and you are at on account of your negligence. Therefore the person who ultimately sustains injuries, or the person who succumbs to those injuries and dies, makes a claim against you. So in common tort law, you would be the person who will be required to really, of course, leaving aside the criminal angle of it and leaving aside you being required to go to jail and serve a sentence, etc., you will be the one who may, under tort, required to pay damages to that person for under various heads, which are your medical expenses, or under heads of pain, heads of suffering, heads of other common expenses which may be there. So under third party liability, you are not required to really pay that. The company from whom you take insurance cover is required to pay that amount on your behalf. So that is not really the subject matter of today's discussion, because that comes with its own set of peculiarities, that comes with its own sets of expertise and its own sets of principles which are different. What I propose to really focus on today is your normal insurance, which comes within three categories. The first part, wherein you are the one who's under the contract named as the person paying the premium, and you are the one receiving the benefits of that premium. So they are divided per se within two types in that category. The first is your, of course, life insurance, wherein you, in consideration for a premium, take a policy, and that policy assures you that, in the event of your death within the period of so and so years, or there can be any upper limit within the period of this, or within a period of so many years, etc., you would be given an X amount of premium. Now that is not really dependent per se, like in case of third party liability, on your income, or on what damages really are sustained by you. It simply is a contract which is not of any set of indemnity, but is a contract of assurance, telling you that to really secure your future, you are required to take that life insurance policy, saying that if I have an untimely death, I'll at least be my family will be given X amount of money. And from that money, probably, of course, nobody can bring back life, but that from that money they'll be in a position to really come forward and really be in a position to perhaps continue the same lifestyle as in what they were continuing. So generally, all contracts of insurance are, they will not go by the textbook definition of what really an insurance contract is, but you may just understand that there is a premium which you are paying as a consideration, unlike any other contract. And in return of that premium, you get an upper limit which is known as a sum assured, which is a promise from the insurance company, from the insurer, telling you that in the event of any claim, you will be getting X amount of money for actual loss or damage which you will be sustaining. Now, what is it that you ultimately get? Is it some amount that you are entitled to as in by way of a profit, or is this an amount which is fixed in terms saying that you may sustain a loss of say 5 lakh rupees, but you will be under the policy only be given 2 lakh rupees or 1 lakh rupees or something of that. So strictly the definition and strictly going by the very principle, it says that this is a contract of indemnity, and in that contract of indemnity, you as an insurer, you as in the insurer is required to put the insured in the same situation as he may put as he was prior to the date of loss, or in the event the loss would have not occurred. So simply put, you lose a vehicle which is 5 years old in some sort of an unfortunate flood. Now you cannot make a claim out of that vehicle and say that, look, I my vehicle was valued at XYZ rupees. Now I use that vehicle for 5 years. If I were to sell that vehicle in the market, I would be perhaps getting half the value of that vehicle. But now, since this incident has happened, I get the full consideration which I originally paid for years back. And basis that I can sort of, buy a new vehicle within that same bracket. So that is not something which is the idea of insurance. It puts you back in the same position, neither less, and more importantly, nor more. So it doesn't assure you anything in excess of what you have lost as on date. So that is the main principle. Now this principle doesn't apply to life insurance for the simple reason that life cannot be valued. And when somebody loses life, the policy at best will give him some sort of an assurance, as I earlier said, for the family or for whoever he leaves behind or she leaves behind, to say that, well, the person is lost, but on account of the loss of that person, it shouldn't be that the family is sort of, left into some sort of a poverty, or that the income of the family stops. So that is not a contract strictly as in of indemnity. It is a contract which is generally considered as that one of an assurance. It's some sort of an assurance to you, to your family, in consideration of a premium where you assess your risk. And typically what happens is you are somewhere running a sort of a taking a chance by saying that I may be paying premiums for 5 years or 10 years or something, and my life may be insured up to the age of 85. Now, if you cross that age of 85, typically you don't get the money of your premium back. In some policies, there are, of course, complex policies, we'll not get into that, where there can be different sort of benefits, and you may get back that money also, for which so these are policies which are mixed as savings plan or something, which is more so in viewed as an investment and not typically as a typical insurance policy. But here, what is in a typical set of an insurance policy is that you are paying some sort of a premium. In consideration of that premium, you are getting your risk value. Now you are getting a promise from the insurer that within a period of say 1 year, in case of a warehouse that you may insure, if you pay consideration for a premium for a period of 1 year, say 50,000 rupees, and in return they assure you that okay, we have an upper limit or a cover of say 50 lakhs or 1 crore rupees. In case within a period of 1 year there is a fire or there is a flood or any kind of a peril that takes place in your premises, we will be bearing the loss to the extent of what you have suffered. So, and in the event that loss does not take place, you cannot go forward and say that, look, I want my premium back because the loss did not take place. So, this is somewhere assessing a risk. It's different from a wagering contract, but this is somewhere assesses a risk, and it really gives you a hope that in case something goes wrong, you are entitled to some sort of benefits. But these benefits cannot be dragged on, or cannot mean something which includes or which entails profit generation. So profit generation is not the idea, not the motive of it. Now, how does a contract take place? What are the essentials, or how really do you get into a contract, and what are the important facets of the same? So, unlike any other contract where there is a proposal and there is an acceptance of a proposal, a contract of insurance is generally governed by the doctrine of uberima fide. Now, uberima fide literally translates in English to mean utmost good faith, which is to say that both parties to a contract are really required to maintain utmost good faith by disclosing all facts within their knowledge And by such disclosure, they are putting each other to sufficient caution in reference to the risk that they are bearing. Now, what does this simply mean? Say, suppose you are a patient suffering from hypertension, suffering from diabetes, and you seek insurance cover. And there is another person who doesn't suffer from hypertension, doesn't suffer from any ailments, etc. The company, while assessing your risk towards life or while assessing your risk towards your health insurance, will be in some set of a caution by saying that, look, this person already has comorbidities, and this person may perhaps is at a risk of another hospitalization, is at a higher risk than compared to another person not suffering from comorbidities of getting into the hospital. So therefore, the risk which the company may obtain, or the which risk which the company is exposed to, is at a higher threshold in comparison to what a person without comorbidities would really have. So they are entitled to charge a higher premium to you. And for another person, they may assess the risk, or they may assess the risk at a lower premium. Or in your case, they may say that, look, since you have so many comorbidities, we will be entitled to charge a higher premium to you, or we may not assess your risk at all by saying that, look, you are at a risk, perhaps at a risk of dying within a period of 1 year or dying within a period of 2 years, considering your medical history. So the contract of the principle of uberima fide essentially says that both parties are required to be put to strict sort of exposure as regards each other's risk, and there must be complete disclosure on all counts. Now, this disclosure, of course, and is on the part of the insured, and it's often used in courts against the insured by saying that while we entered into the contract of insurance, there was no proper disclosure by the insured, and thereafter, since there was no disclosure, we have a right to repudiate. We'll deal with that issue later on. But it also equally applies to the insurer by disclosing all terms and conditions, all exclusions, all facets of the cover to you by saying that, look, this is what you are obtaining, and in case of you obtaining this etc etc will be covered, etc etc will not be covered. Now, put it simply, for instance, you seek an insurance of a mediclaim policy, and they say that we'll be giving you mediclaim for xyz treatments. Now, there is a certain innovation, or there is some kind of a treatment which is medically very popular, say for a heart procedure. The company has to put you to notice that this procedure will be covered or will not be covered. So it shouldn't be that they come forward, they give you the contract, it's everything is signed, and later on when you make a claim, they turn around and they tell you that, look, we'll of course pay your bills, or we'll honor the claim, etc. But subject to you having incurred expenses for XYZ procedure, not for ABC procedure. So this applies equally to both parties. Whatever was suppressed, if the insured suppresses something, if he suppresses something or she suppresses something, the company has a right to later on repudiate the claim. And if the insurer does not disclose the particular terms and conditions at the time when the contract is entered into, the insured also cannot be put at loss, and he has a right to agitate that kind of a claim. Now, what are the valid essentials? Not to really look at the textbook definition, but what are three or four valid essentials which really brings in a contract of insurance, which are required to be there in a policy of insurance? So the Supreme Court, in the case of Vikram Green Tech versus New India Assurance Company, has culled out those three or four valid criteria which they say should be there in any insurance policy. So the first is the definition of risk. Now, what is the definition of risk? If a policy is insuring risk for fire, it has to, in clear terms, set out that the policy is giving you risk for fire. If it is setting out risk for flood, it has to give out the risk for flood. It cannot be ambiguous, it cannot be cryptic somewhere by saying that, look, fire is covered or flood is covered, but nothing is really written in the policy. It just says in case you suffering damage, you are entitled to make a claim, etc. So the definition of risk has to be in clear terms written down in the contract, and the policy and the company through the policy has to speak to the insured and say that this is the risk which we are covering under the policy, this is the risk which we are not covering under the policy. For instance, you often have, I mean, the most typical form of policy which is often taken by persons who are business houses is a standard fire and special perils policy. Now, in those cases, what the policy sets out is that fire, if there is loss caused on account of fire, the risk will be covered. If there is loss caused on account of flood, the risk will be covered. However, what will not be covered is, for instance, you are having a factory premises and the local corporation, by way of an order of the court or by way of an order of the corporation itself, comes out and demolishes your building. You will not be entitled to make a claim. So it specifically excludes loss caused on account of any of those orders of the court or loss caused on account of any of those orders by a municipal corporation, etc. So in those cases, you can't later on say that okay, it's not out of flood, it's not out of fire, it's out of some kind of a demolition caused by the, say, the local municipal authorities, and nonetheless I have suffered the loss, I am able to establish what my loss was, and you give me a claim. So it will fall within any of those exclusions which are set out in the policy, and therefore you cannot be making a claim. So definition of the risk for the insured as well as for the insurer is something which has to be reduced in writing. It has to be specifically written and said that this will be the definition of the risk. Now, the second is the duration of the risk. Now, what entails the duration of the risk? So, a policy typically, if you have those your typical general insurance policies, they commence and they end within a period of 1 year. So it says that now, say today, if it is the 13th of December, the policy will start running from 13th of December, say by midnight, and it will end on 12th of December at 11:59 in the year 2000, in the year 2006. So the duration of risk has to be met out. Now there can be no and this may of course seem very obvious, but of course there is litigation even highlighting problems on duration of risk. Now suppose the duration of risk ends on 13th of December 2016 and the insured meets with some sort of a fire in his processing house on 14th of December or 15th of December of 2026. They cannot thereafter turn around and make a claim for the simple reason that the claim is made at a point in time which is beyond the duration of the risk. The third is the premium. Now, like all contracts have to be for a consideration, the insurance contract also simply has to be for consideration, which is known as a premium. Now, premium is something which, without which the risk will not be assumed, and there is a statutory backing to that concept that once the premium is paid for XYZ amount, the risk will thereafter be assumed, and without payment of premium, the risk will not be assumed. So, the premium also has to be stated within the policy. The second is the amount of insurance. Now, popularly, this is known as the sum assured, as to what is the upper limit within which the company will be liable. Now, say take a claim of a business house which has suffered a loss of 50 crore rupees, and they, in consideration of a premium, they undertook a policy for 20 crore of rupees. Now, just because a claim is made and that actual loss may have been sustained, may have been proved by that particular insured, just because it is to the tune of 50 crores, it cannot be paid by the insurance company for the simple reason that the sum assured has a upper limit of 20 crore rupees. So now, does it mean that when there is a sum assured of an X amount, does it mean that the company guarantees you to pay that amount? The answer is no. The simple reason is that the sum assured is nothing but an upper limit, and the company can, at best, or it merely shows the maximum liability that a company is required to assume. So if you suffer, say, loss in your factory premises for a machine which is valued at 10 lakh rupees, and your sum assured is 5 crore rupees, it does not mean that the company will come forward and give you the total 5 crore rupees merely because it is the total sum assured. The simple thing is that the company is entitled to only, as I said, indemnify you for actual losses and actual damage suffered by you. So sum assured acts as an upper limit, and it is often on pro rata basis to the premium which is paid. Now these are all technical terms which were earlier set out by something known as the TAC, which is the Tariff Advisory Committee. Now that committee used to uniformly set out the premium rates for a particular sum assured, and also set out general terms and conditions and general sort of exclusions which will find place in the policy of insurance. Now, so these are fixed, and it doesn't mean that just because the sum assured says 20 crore rupees, you are required to somewhere, pay the amount of 20 crore rupees. It simply says that this will be an upper limit, as I said, and upper limit only to the extent of you showing actual damage or loss coinciding with that upper limit. Now, what are principally the regulations which are, or the laws which are, or statutes or legislations which are dealing with insurance? So there is an Insurance Act of 1938, which somewhere it postulates what I said earlier, that there can be no insurance without a contract. In terms of Section 64 VP, the Act says that, no risk will be assumed in the absence of there being payment of premium. The second is it also sets out as to what is required to be done, how a claim settlement is to be made, how a claim is required to be made, what are the powers of the company, and it basically consolidates and brings in a legislation. The second is the Insurance Regulatory and Development Authority of India Act 1999. Now, what had earlier happened is, now when you look at the old textbook definitions, and if you pull up any commentary, one of those commentaries that I read, it says that initially when those contracts, late early in the 1600s or 1800s, when these contracts used to be formed, at those times, typically what used to happen is that a person would really gullibly trust somebody and say some sort of a banking house or a insurance company, as you may call it, would be floated. They would say that, look, you pay us an amount of so and so rupees, we will assume risk for your goods which will be shipped from this country to this country, and whenever you, if you lose them, actually we will be entitled to give you a particular payout. Now what used to happen is essentially those persons used to either disappear, or they never had the bandwidth to really assume risk, because ultimately anybody would, or even a layman would really ask a question by saying that, I am paying consideration of a very less value, and in return, I am getting a promise of a huge hefty amount which will be indemnified to me. So, how does it work? What is the profit that a company can really make? And it sort of, assume some sort of non-effectiveness when it came to actual practicality, or when it came to actual enforcement of these contracts. Now, this continued for a while, and different countries went on to undertake legislations. In India, this was the onset with the Insurance Act, and earlier there were certain legislations which were there. We'll not really typically go into the history of what was there, but the legislations came into place for the simple reason to codify the law, to sort of come forward with a scheme wherein, in the absence of there being, and to bring forward some sort of accountability, to say that if there is absolutely no accountability, nobody would really be trusting in this kind of contract, and people, gullible persons, might actually keep paying premium in exchange of a hope that, in case I suffer a loss, I'll be given XYZ amount, and ultimately no amount would be given. So this brings in your consolidated legislation, which sort of, sets out in terms of the legislation, that these will be the safeguards given to the insured, and these will be the premises on the basis of which the insurance companies are required to act. Now there was a further need of really consolidating, of really having a specific body which looks into complaints against the insurance company, which looks into some sort of, everyday consolidation of how the insurance industry is behaving. For that, the Insurance and Regulatory Development Authority of Act, IRDA Act, as I said, of 1999, creating the IRDA as a body came into place. Now, IRDA was created as a body to really oversee business insurance and reinsurance business in India, for the simple reason that all companies really were required to come into some purview of check, wherein they were not really leading, duping gullible persons who were not having the capacity to fight them. And basis that, the IRDA Act of 1999 was really promulgated. IRDA was created, and thereafter IRDA was now enjoys a host of powers, wherein, from looking at taking disciplinary actions against companies, to really overseeing claim settlement process, to also bringing out a change with changing times, bringing out a change in terms of the regulations, in terms of the rules, and in terms of what really can possibly lead to a dispute, and if there is a dispute, how does one sort of, take it forward. So that is how the act came into place. Under the act, there are several regulations. I'll deal with some of them which I think are of most relevance. There are several regulations dealing with how a claim settlement procedure, in terms of a general insurance policy, or in terms of a health insurance policy, or in terms of a life insurance policy, is really required to be dealt with. Now these regulations came forward, and they showed that, if there is a claim lodged, it put the company to certain sets of accountability, saying that if there is a claim lodged, you will, in this amount of time, revert to the person. You are required to do XYZ, and the insured is required to do XYZ, and this is how the claim will really typically stand. Now, this, why were the regulations promulgated initially, was that in India there was absolutely no specific or strict timeline in which a claim would probably be processed. Now, why the timelines were very much important is that under the Insurance Act, you have a section 64 which says that whenever there is a loss reported to the insurance company, since this is a contract of indemnity, it will not really be simple to assess the loss by saying that I lost this, this was the invoice copy, this is why I purchased it, now you pay me this amount. So the Insurance Act provided for the conduct of a survey. Now, under 64 of that act, it basically says that there will be a person who will be recognized as a survey licensed surveyor or loss assessor. He will be on the empaneled with the IRDA or be licensed by the IRDA, and by getting that license, he will be a fit person to really assess the damage. Now, why this need? When you say the contract is one of indemnity, the most obvious question somebody would really ask is that, look, I have lost my storage premises, I have lost my stock, and why does one need a surveyor? I am able to prove my loss by showing my bank books, my passbooks, my accounts that I have incurred XYZ expenses in terms of some machines, in terms of some raw material, let it be cloth or anything. And basis this, I am entitled to this amount of money, which is my claim. Now, when you say the contract is one of indemnity, why do you need a surveyor? Simply is, let's say, for instance, you have used a machine. Now, that particular machine is there in your factory premises since the year 2010, and you purchased that machine initially for a sum of rupees 10 lakhs. Now, after that machine was there in your factory premises, the loss takes place somewhere in the year 2021. Now, what really happens? Are you entitled to that sum of rupees 10 lakhs in the year 2021 itself just because you lost a machine which was originally valued at 10 lakh? The answer is no. Because since this is a contract of indemnity, you are required to be put into the same position as you were in the year 2021. So if you were to say sell that machine in the open market, had the loss not taken place in 2021 or whatever may be the year, you would not be entitled to the original market, or you would not be entitled to the original value as on that date when you purchase the machine, but as on date when you were selling that machine, there will of course be some sort of a wear and tear in that machine, and that machine of course doesn't have the same life as it had earlier. So there are complexities in assessing the loss in that sense. What those complexities are is that the surveyor typically comes forward and says that, okay, now this machine is there, you use it for 10 years, so I'm going to pick up something which is known as a depreciation. Since this is a depreciating asset, every year it loses its value, it loses its strength to some negligible or serious level, and thereafter, this according to me comes out to be the value. Now, this is very typically done in for plant and machinery claims. This is very typically done even for claim for stock claims. It's very typically done even for claims of building, because as I said, even a building which was erected in the year 1973, for instance, will must have undergone sufficient sort of if not dilapidation, but sufficient sort of wear and tear. And if the loss takes place after a good 30 years or 20 years or 10 years, the building doesn't have the same capacity. So to put back the insured in the same position, the Insurance Act contemplates that the loss can only be assessed by a surveyor, and it is not that the surveyor, the same section which provides for the surveyor to be appointed, says that the surveyor's report is not something which is binding on either the insured or the insurance company, and any of them, insurance company or the insured, could appoint a surveyor, but no claim can be processed in the absence of appointing a surveyor. Now, what used to happen, the Insurance Act did say this, but what used to effectively happen is that often, and in 99.9% of cases, the claim would be lodged with the insurance company. The insured would typically have no idea at all as to who is a surveyor, who am I to go to. He would just come forward with his bills at best and say that this is the losses that has been caused and this is the claim that I'm making. Now, after making that claim, the company would, from its panel, because they were of course in the regular business or regular practice of settling claims, they would from its panel come forward and choose a surveyor and say that, look, this person is there, he's been appointed as a surveyor, and he will conduct a survey. Basis this, we'll take a decision into the claim. So this has gone on for years. The surveyor often acted with no accountability. In many cases, they would come forward and not assess the loss for a period of years, say 1 year, 2 years, or 5 years, or even 10 years. And thereafter, after they take their own sweet time and thereafter say that, look, now this is there. The company thereafter would take their own sweet time to process the loss, and the insured at the end would have really no recourse or would really not be in a position to understand what is required to be done. So To really beat this, the IRDA was set up. After the IRDA was set up, time to time, the ground realities are reviewed by the IRDA, and they came up with regulations. So first in 2002, they came up with something which is known as the Protection of Policyholders Regulation. These were then revised in the year 2017. Now, what do the regulations say? Effectively, I'll not read the terms of the regulations one by one, or what is really there in the rules, but just to give you a summary, what do the regulations say? So, for instance, the 2017 regulation, it sets out a claim procedure in respect of any insurance policy, be it your general insurance policy, your life, or your health insurance. So the regulations typically provide that an insured is required to lodge a claim at the earliest. If there is a fire that has taken place, you are now within a period of 1 or 2 days best on. Of course, no strict timeline, but at the earliest opportunity, lodge a claim with the insurance company. And the company at the earliest occasion has to deploy the surveyor. So this really takes away the time or the delay that would have resulted in the absence of there being no regulation to oversee the time on the part of the company or on the part of the insurer. Thereafter, once the surveyor is appointed, the surveyor is within a period of 30 days required to come forward with his survey report and say that, look, this is my assessment. It has to be forwarded to the company. The company has to review the assessment. If the company has no doubts or queries, they are required to settle the claim within a further period of 30 days. And if in case they have doubts, in case there are complexities and intricacies which are required to be discussed, under intimation to the insured, the company is then required to go back to the surveyor and say that, look, we have doubts on this. Please clarify your position. And once the surveyor brings back the additional report or brings back the clarifications to the company is required to settle the claim. So the regulations also provide that if the company, on the receipt of the last document or the survey or whatever may be the last document, if it doesn't settle the claim within a period of 30 days, it is obligated to pay to the insured an amount, interest on the amount at a rate which is 2% above the prevailing bank rate. So these brought in some sort of strict timelines. Now, of course, I do not suggest that these are strictly adhered to. There are surveys which are not often on account of faults of the surveyors, but are often on account of the complexity of the matters, taken a point in a long period of time for the survey to be conducted. It often doesn't happen within a period of 30 days, and the company also, for its own set of clarifications, etc., puts back, and it is not something which is settled within the prescribed timelines. But what it brings in is it brings in a sense of confidence for the insured, and more often than not, now with the changing jurisprudence also on this, the courts are quick to say that you are required to settle claims within so and so time. They are enforcing this interest regulations, and therefore it's creating some set of accountability and also creating some set of confidence. So this was a statutory framework or the legislative scheme of what insurance typically has to offer. Now, if you look at the act more so, you will not really be, gaining any concrete idea on how those claims are settled or concrete idea on how those matters are also dealt with, because the statutes in that sense are dry. They provide rules, etc., but they have a large part of the jurisprudence has evolved on account of interpretation of those statutes by the courts. Now, say you have your policy, you went through what a contract is of insurance, you had your policy, you took it into account, you even unfortunately sustained a loss. Now, once the loss is sustained, what do you do? Of course, apart from what the survey the regulations say, but what do you do once the loss is there? And in case of there being a dispute, suppose, of course, if your loss is there, it's settled by the company, there is nothing required at your end to be done. But if, for instance, your claim is there and it's rejected, or you are unhappy with the settlement or the assessment, what are you required to do? Now, before getting into that, what are the effective or what are the most popular reasons for insurance disputes, as to how does it come within the legal landscape, and how does a dispute typically evolve? So the first is, you have made a claim and you have written to the company. The first and the most typical type of the dispute is when the company tells you that, yes, you have made a claim very well, but in light of etc conditions, you have made a claim, but you are in breach of certain conditions, and therefore we will not be able to honor your claim. So what they typically write to you is something known as a repudiation letter, and they say that you made a claim, but well and good, but you've breached the conditions, and therefore we are unable to honor your claim. The second kind of a dispute is that when you are, which is typically known as a quantum dispute, is that you made a lodged a claim for 20 crore rupees for incident which took place of fire which took place in your factory premises. And the company says, yes, you've sustained loss. You are also not breached any of those terms and conditions, etc. But you have we've assessed it under the since it's we've assessed the loss by the surveyor, and now the end amount payable to you comes to 2 crore rupees. So there is a huge gap of what you've actually claimed and a huge gap between what is actually being offered to you. So in those sets, you feel that very well, my claim has gone through, but what they are offering me is not something which I am entitled to. It's something far more. That my entitlement is something far more, and therefore that is typically known as a quantum dispute. Now, coming back to the first set of disputes, why do disputes typically take place? As to what is it that leads to a dispute of or leads to a repudiation of the claim? So again, dividing it again into two, your health and your life insurance claims. Typically, the dispute takes place on account of there being a suppression in the proposal form, wherein, as I gave an example earlier of hypertension, diabetes, somebody since the industry is not so typically regulated in the country, people still have a mindset saying that, look, I'm just required to sign something, take a policy, and thereafter when there is a claim, I'll look into it. So in that process, what they do is generally often the industry is regulated by what is known as insurance agents, and they tell you that, okay, fine, to get a policy for this amount at the cheapest possible premium, I'll fill your proposal form and I'll write over there that there is no ailment, there is nothing, there are no pre-existing conditions, and basis this you'll get the cover. Ultimately, when you make a claim, nothing will really happen, and they'll honor the claim. Nobody will get to know that you've suppressed them. So that being the first line of disputes, and this is often, I mean, the companies do take up this recourse very often, and there is often what you see is that the insured is at fault of for want of knowledge or for want of proper guidance, or sometimes intentionally is guilty of suppressing material facts. Now, what is suppressing material facts? As I said, the proposal form forms the touchstone of your contract. In that proposal form, which ultimately results in the acceptance, if you have not disclosed anything, it gives the right to the insurer to repudiate your claim, whether it has a bearing to your ultimate loss, or it does not have a bearing to your ultimate loss. Now, what is it meant by bearing to the loss? So, giving you an example, for instance, a person who's suffering from cancer takes out a policy, and in that policy writes that, no, I am not suffering from any ailments, etc. Ultimately dies of cancer after a period of a year. The company repudiates the claim, and the company's reasons for repudiating the claim, as even a layman would feel, is that you suppressed cancer, you died on account of cancer, and since you have died on account of cancer, we were never put to the knowledge of the actual risk that we were assuming, and had you disclosed it, perhaps we would have charged you a higher premium, or perhaps not given you insurance at all. Since you have suppressed this, we are not required to really honor the claim. Now, this is something which is typically known as a fact or a disclosure, non-disclosure having a direct linkage to something which is the cause of death. The second is that, for instance, a person is asked in the proposal form that how many previous insurance policies are you holding, and he says that, no, I am not holding any policies, and he is then asked, he ultimately dies of a cardiac arrest after a period of 6 months or a period of 1 year. The company still repudiates the claim and says that, look, you may have died on any circumstances, you may not have any ailments, you may not have suppressed that you have any ailments, and sorry, you may not have suppressed any of your ailments, etc., but you have still suppressed that you held previous insurance policies. On that ground too, we are repudiating your claim. So the question is, and a normal person would ask, is that what prejudice would it cause to the insurance company in terms of assessing the risk, as to there being a non-disclosure on of previous health insurance policies? So the answer to that is that the company, yes, still has a right to repudiate the claim, no matter how strange it may sound to a layman, for the simple reason that even previous health insurance policies can be a material fact for the insurance company. And what is a material fact is not necessarily a fact directly having a link between the suppression and between the actual cause of loss. It could be anything, and the company may be suspicious of insuring somebody who has 50 insurance policies by thinking that probably, he's insured his life with 50 companies, thinking that he's now not going to survive more. So we still have a idea of really looking at the risk that we are assuming. So any sort of a material, now any sort of a suppression in the proposal form really gives a right to the insurance company to repudiate your claim, no matter as harsh as it may ordinarily sound to somebody who's not or who's somebody who's a layman. So when a party affixes his signature on the proposal form, there are no defenses available to him by saying that my agent filled in the form. And this has been very illustratively captured by the Supreme Court in one of those judgments of Reliance Life Insurance Company versus Rekhabin Rathod. And what, in fact, the ground for repudiation which was upheld by the Supreme Court was of non-disclosure of previous existing life or health insurance policies. And what the court held is that what is a material fact is not something which the insured can decide. Whatever is there in the proposal form, any non-disclosure of the same will amount to a material fact in the eyes of the insurance company, since the proposal form itself is some sort of a dialogue between the insured and the insurer, and basis the disclosures given over there, somebody can really have idea of what is the risk that is to be assessed or not to be assessed. So these are the most typical type of suppressions and most typical types of disputes that take place, especially in life and health insurance claims. But they also can take place in a general insurance claim, because even that policy is nothing different. It comes forward with a proposal form. Now, the second limb as to what is it that is there in general insurance policies, and what if the proposal form. So before I, of course, begin with that, what if the party chooses to keep a column blank? For instance, you are asked with, are you suffering from hypertension in the proposal form, and you neither tick yes, neither did you do you tick no. So interestingly, the Supreme Court says that and companies have often argued by saying that even by not disclosing anything or just keeping the form's column blank, there is a non-disclosure, there is a suppression by by the insured, and thereafter that also gives a right to the insurance company to repudiate the claim. But the Supreme Court disagrees. What the law laid down by the Supreme Court on this is that if there is a blank kept in the proposal form, the insurance company is under a specific obligation to call the insured and say, please fill this blank. If they do not do so, if they really omit, or if it really omits their eyes and they do not do anything out of that, they are required, they cannot later on turn around and say that, look, by leaving a blank, you have made a material suppression, or by leaving a blank, you have made some sort of a misrepresentation to us. So the law is, if a blank is there in the proposal form, it does not constitute to be a material suppression. But over and above, otherwise, the proposal form is a very important document, and that really is the genesis of disputes in lot of cases, and at least 90% of cases which are there under health and life insurance policies, as I said. The second is your warranties and your terms and conditions. Now, distinguishing them from warranty, distinguishing these two terms, warranties and terms and conditions. Now, what is typically a warranty? Warranty is something which the company would write. If you peruse any policy, you will see that the company has warranted that XYZ. For instance, now if there is a claim, or if there is an insurance policy given for a particular machine, the company will ideally in the insurance policy tell you, warranted that there is an annual maintenance contract of this machine made only with the original equipment manufacturer. You so To simply put, you can't really service that machine with any other company, or you can't service it with somebody who is doing it for a cheaper rate, or some sort of a mechanic or something like that. And basis that, if that warranty is not adhered to, it automatically gives the right to the company to repudiate the claim. For instance, you are running a machine, and the warranty says that you have to do an annual servicing with that original equipment manufacturer, and you do not do that. The company still, no matter what the cause of loss will be, the company will still have a right to repudiate the claim by saying that you have breached a warranty. Now, contrary to this, the terms and conditions have to be directly relevant to what is the cause of loss, or terms and relevant have to be directly relevant to what is the cause of repudiation. For instance, there is a terms or some sort of a condition saying that the goods which are stored in a particular shed or in a particular area of the premises will only be covered. If that term or condition is breached, the company still gets a right to repudiate it, but the company can still make payment, or the company is still under the obligation to make payment of the balance goods which are not stored within that particular area. Now, typically, to just explain this better, what really happens in factory premises is that there are policies given where these policies come forward and say that there is a open shed, and there is a shed, and there is also an open area. Now, goods which are stored in the open area will not be covered. Goods which are stored in the shed will be something which is covered. Now, if you have goods lying everywhere, if this is a term or a condition of the policy, the goods which are within the shed will be covered, but the goods which are outside will have to be excluded. However, if this comes as a warranty saying that if at all we find anything stored outside, we will not be liable at all. The warranty can mean that the contract did not, I mean, so the contract was misrepresented from the inception itself, and the breach of warranty, relevant or not to the cause of cause, will become a ground for repudiation. To give another example, for instance, the warranty says that there is like your annual maintenance contract to be done by the original equipment manufacturer, and ultimately the problem in the machine doesn't occur on account of any maintenance issue, but it occurs on account of a fire, wherein it's absolutely of irrelevance as to whether the machine would have been serviced by the OEM or not serviced by the OEM. Once the machine is lost, it's not of any relevance to the typical condition or the typical warranty which is there in the policy. Still, the company gets a right to say that since you breached the warranty, you can repudiate the claim. So these are typical basis of repudiations wherein there is a breach of policy terms or conditions, breach of warranties, or there is a material suppression, or there is a non-disclosure in the proposal form. The third is the company using exclusion clauses within the contract. So what is an exclusion clause? Now, typically you have contracts of all kinds of natures which come with some sort of a caution for protecting either of those sides, saying that look, in these of course are there even in your builder contracts or in your simple agreements, saying that in the event of XYZ happens, liability of the company will exist. However, if so and so happens, the liability of the company will not exist. Now, to put this simply, the exclusion clause may say very simply that if at all you lose your particular device or you lose your particular machine on account of fire, we will be liable. However, if that fire is caused by you itself, then we will not be liable. So that exclusion clause sort of is within the scope of the cover. The scope of the cover, first of all, being fire, and the exclusion clause being within the scope of the cover carves out some sort of an exclusion, saying that in this case, fire may have been there, although the first part says that the loss caused on account of fire will be covered. However, it comes with a rider, it comes with an exclusion saying that if the fire is caused by you, it will not be covered. Now, how does one really, because this is also some sort of a issue which very typically comes forward for your litigation, wherein the companies are often using exclusion clauses to deny payments in terms of claims. Now, how do they deny payments in terms of claims? They often use some kind of an exclusion clause saying that, look, the cover may have been triggered, but since the clause says that in the event of this triggering, in the event of another event happening, or in the event of another event not happening, we will not be at risk. So often the Supreme Court has said that these exclusion clause at various points in time, one, are many a times ambiguous. Now, what is ambiguous? The clause is worded in such a way that it lends itself to either two interpretations, or it lends itself to an interpretation which is not very specifically understood from it. So in that case, what happens? The Supreme Court has called out something which, I mean, which is pressed into service in this kind of disputes, is something known as a principle of contra pro forentum, which says that in a standard form contract, like a contract of insurance, which is of course a standard form contract, when you go and give your proposal form, you will not be at a position to bargain and say that you keep these conditions. You give your proposal form, and the contract comes to you. So within that, you cannot really have a bargaining position with the insurance company. So that being a standard form of a contract, the court goes on with a presumption that the maker had all liberty to put in with all clarity all sorts of safeguards to himself, all sorts of exclusions, all sorts of terms and conditions. And in the event, still the maker lends itself to any ambiguity in those settled terms and conditions, that the ambiguity will have to be resolved in the favor of the other party. Simply put, ambiguity will have to be resolved in favor of against the maker. So what is the doctrine of contra pro forentum? If there are two views sort of possible, or the term or the condition lends itself to two possible interpretations, the interpretation suiting the insured will have to be adopted, for the simple reason, as I said, that the company was at liberty to safeguard itself by writing everything into writing, and still if they make some sort of a mistake or leave it to the vagaries of ambiguities, then it has to be a fact which has to be go against them. So that is contra pro forentum. The second is that the Supreme Court has held from judgment to judgment that when the company takes shelter to an exclusion clause, the company has the onus and the burden to prove that the exclusion clause is ticked in, and that the facts or the claim falls within any of those four corners of the exclusion clause. Now, to give an example, the Supreme Court in the case of Tata AIG versus Texaco Marketing in the year 2022 dealt with a situation where there was an insurance cover for a shop which was situated in a basement of a particular building. Now, the policy entailed that we are covering the shop, but which was admittedly situated in the basement. But the policy also came up with an exclusion clause saying that we are covering the shop, but we are not covering the basement. So now, what does it say? Ultimately, when the claim was made, the company repudiated it on the ground by saying that the shop which is in the basement is not covered by virtue of the exclusion clause. So the court said that this is nothing but some sort of a sheer deficiency in service by the company, and it's completely misleading the end consumer by really selling something to him which cannot be honored at all. For instance, to say that I say that I'll insure this particular computer only if you don't use it, or only if that person ultimately no loss is taken place on that computer on account of using of that computer. Now that is something which is really impractical. So the court propounded something which is known as a doctrine of blue pencil, and they said that if there is some kind of an exclusion clause, so interpreting the clause and the very meaning of what an exclusion clause is, the court went on to say that that is a clause which takes its birth from the main preamble or the main contract. It does not have a life of its own, and it is not something which can become so powerful to ultimately defeat the purpose of the main contract itself. So they said that any of these exclusion clause, which when read with the main recitals of the contract, if they are defeating the very purpose for which the insurance were taken, or if they were defeating the very cover of those clauses, they are required to be somewhere, and allegorically saying, struck down with a blue pencil. So that is effectively the doctrine of blue pencil. And it strengthened the idea of giving hopes to the consumer or insured, saying that if there is a claim of this nature where the company is misusing the exclusion clause, or really coming up with policies in such a nature, which you typically say, as people say, that lawyers draft contracts in such a way that ultimately that interpretation will be used to protect the person who's drafted the contract. So it says that you can't really come up with such kind of clauses that ultimately the end result is that you are not required to pay out anything. So those kind of exclusion clauses are something which are looked down upon, and it cannot be something which can really defeat the end purpose or the end result of the contract as such. So those are the broad outlines. The last, the other being the dispute. Now the second part being the dispute on quantum. Now what really happens on a quantum dispute? The company doesn't use any exclusion clause. The company doesn't blame you for breaching any terms or conditions. The company also doesn't blame you for coming up with any material suppression in the proposal form. But it simply says that yes, you made a claim for damages to a particular plant that you have set up somewhere. Now, on account of this being a contract of indemnity, you may have incurred 50 crore rupees in setting up the plant, but your plant was 20 years old. So now the end value which you are really entitled to is only 1 crore rupees, or only 50 lakh rupees, or 2 crore rupees. So those are disputes of quantum. Now, what typically happens in those disputes is that the company, by and large, in all probability, relies upon the report of what we discussed earlier of a surveyor. And the surveyor's report is somewhere there, and it says that this is not to be paid, that is not to be paid, your depreciation is to be calculated at this rate, thereafter the rate has to come out to xyz, and your goods which are stored over here were old, so therefore the stock is dead, you are not entitled to amount of that. So these are typically known as quantum disputes, and quantum disputes are often agitated by way of an arbitration. And what really happens is that the how does one deal with in the legal recourse is that the insured comes up with something looking at the report and says that the report of the surveyor may be a report of an expert, but that expert has made perfunctory remarks, he has made erroneous deductions, and thereafter, on me leading evidence, me showing my proof of loss, these deductions cannot stand. And those are how those litigations are usually sorted out. And they can of course be complex in terms of their determination, for the simple reason that it deals into an arena of which is not typically law oriented, but it is typically that subject oriented. For instance, for lawyers it will not be possible to calculate the depreciation on a mobile phone which is 5 years old, or to calculate the depreciation on a computer which is 5 years old, and also another computer which is 5 years old but has been used in a different particular manner. So those are, of course, disputes on quantum. Now, how does one deal with issues in choosing the right forum, as to where does one go with their set of disputes, and what are the available avenues available with a particular insured to go to court or go to some specific forum, or what does one do? So there are four broad outlines on this. First is, of course, the person or the claimant filing a suit, typically saying that we have suffered a loss of so and so. The claim has either been rejected or has been paid to a very paltry amount, which is not agreeable to us, and therefore they lead evidence. They have to set out what they are required to do is set out actual loss that is suffered by them, show that the report of the surveyor, if that is the case, is bad in law, it is erroneous, it is arbitrary, it is ad hoc, or something of that kind, and also show that, look, the dispute has been wrongly agitated by the defendant or the insurance company, because there were absolutely no grounds of dismissing the claim or repudiating the claim. So that is a very typical first remedy. The second remedy is, now, of course, before we go to the next, the drawbacks which a suit really has is your time, which is there in any particular suit. You file a suit, you have sustained losses, you are anyway under a bad financial situation, you have sustained losses, and thereafter you are now left with no monetary advantage to really fight a corporation who is at a much better, higher pedestal economically to really fight you. So that takes, so which is why suit is not something which is a very preferred remedy. And of course, not only in insurance claims, but in most matters, people prefer going to designated tribunals, or people they try taking up alternative mechanism. So suit is, of course, the first remedy. The second is, you have something which is set up by the act itself as an insurance ombudsman. Now, what does the ombudsman do? It, unlike a suit, there is no leading of evidence. You are not required to really sort of step into the witness box, and you are not required to lead evidence. Somebody is not going to cross examine you. It's going to happen in a very, very summary nature. You are somewhere required to, and of course, it doesn't even involve lawyers. So you go before the ombudsman with a complaint. The ombudsman asks the insurance company to present, without any lawyers, its written version of what their facts are and why have they repudiated the claim, or why have they not paid out the claim. And thereafter, the ombudsman arrives at a decision by really summarily looking into it. And the scheme is by and large such that he is required to lean in favor, or he is required to take a view which favors the insured. Of course, he can't rewrite the terms of the contract, or he can't do something which is illegal, but he is required to sort of take into consideration both aspects and try to make it as a grievance redressal mechanism, and make it easy for the ultimate insured to approach before it. And it has to save time, it has to really save the whole burden of a party going into the box, leading evidence, proving its claim, etc., etc. And the rigors and the procedures of CPC are not at all remotely also applicable to it. Of course, it purely proceeds on the basis of those settled natural justice principles, where somebody comes with a complaint, the other side is heard, and the decision has been taken. Now, as good as it sounds, why do all claims not really go before the ombudsman? Which are parties which really go to the suit? Now, the ombudsman comes with limited powers. They are not really entitled to agitate on serious questions which can only be proved by leading evidence. It is a summary jurisdiction. It is more summary than even your designated tribunals. So it's some sort of a summary jurisdiction. And also, the ombudsman earlier had a cap of not making a payout exceeding a sum of rupees 30 lakhs, and now has a cap of not making a payout of a sum of rupees 50 lakhs. So who really goes to the ombudsman, and who is really making claims before the ombudsman? So this is a specific remedy created those persons whose claims on medic claims, or whose claims on life insurance policies are rejected. And ultimately, sometimes, say you go to a hospital, carry out a procedure which is for a sum of 5 lakh rupees, and that claim is rejected. Now, you don't want to go to the court and file a suit, for the simple reason, of course, being the time. And the second is that no lawyer is really going to entertain you for, in all possibility, by saying that for a sum of 5 lakh rupees, what will be the fee that you will incur, and how much. It's really not worth the effort, in a short, in a nutshell. So therefore, these claims, the ombudsman has been successful in granting reliefs, and bringing out a very beneficial or a benevolent mechanism to a lot of these peoples who have those claims somewhere in between, on account of mediclaim policies or on account of life policies. So those are the claims which can really go before the office of the ombudsman. So if you have a very narrow claim saying hospitalization or something of that kind, the best remedy for somebody would be to go to the insurance ombudsman. Now, the next is the consumer forum set up under the Consumer Protection Act. Now, what does that do? You go to the consumer forum. In what cases would you go to a suit, and in what cases would you go to a Consumer Protection Act? Simply put, of course, why is the act set up? It's again set up to really bring advantage to the end consumer, and insurance is the insured is a consumer within the meaning of the act, and it really obviates your delay. It really obviates your long time that is spent by you in a civil suit, and therefore people prefer a consumer of forum's jurisdiction. Now, essentially, if you look at it by the textbook definition or also by the jurisprudence that has evolved on this issue, a party which goes to a consumer court cannot really enforce a commercial dispute. It is not something that I was to make sale of these goods, make profit out of it, and thereafter I'm going to the commission, because that didn't go through. The whole rigors of the act are that you are required to be an end consumer, and you are required to bear in mind that you only being as a consumer can come to the court, and you cannot come to the court for any commercial purpose. Now, all these commercial houses, as we just discussed, all have insurance policies, and after having those insurance policies, they are ultimately commercial entities. The policy is taken by commercial entities, and they can still go to a consumer forum. You may ask me why, as to how is a person who is otherwise not entitled to go for a commercial benefit, even if that commercial house takes insurance, why is that issue being allowed to be agitated by the consumer forum? For the simple reason that this issue came up before the Supreme Court in the case of National Insurance Company versus Harsolia Motors. And what was really argued by the insurance company over there was that the consumer forum cannot be a remedy, because at first breath you say that no commercial disputes can come to this forum, and at the second breath you entertain claims of parties which are actually indeed commercial enterprises like companies. So a company also is otherwise being a consumer. A company who has taken a policy is allowed to come here agitate disputes. It cannot be done in this in the same commission, which otherwise precludes commercial disputes to be adjudicated. So the court fell back to that same contract again, of the same concept of the insurance being a contract of indemnity, and said that a party, even if it is a commercial enterprise, who takes a policy does not take it for to gain a commercial advantage out of it. Since the contract is one of indemnity, a policy, the end money which will be given to the consumer at the end, will not be something to its advantage in terms of a profit. It's not some profit making scheme. What you are effectively doing by the contract of indemnity is putting him back in the same position. So therefore, even if the enterprise is commercial in nature, the even if the business house is commercial in nature, carrying out other commercial activities, the purpose for which they took the policy is not a commercial purpose, and therefore the policy of insurance is somewhere allowed to be adjudicated even before a consumer commission. Now, it doesn't have the drawbacks or the pecuniary drawbacks of what was there, what we saw in the ombudsman's mechanism. It also does not have the drawback of the long duration, what we saw in terms of civil suits. Then why do all disputes not go to consumer commission? For the simple reason that is, of course, not as much as the ombudsman, but this, of course, is a summary mechanism of redressal. And in that summary mechanism of redressal, parties do file affidavits examination in chief, but parties don't come forward and lead evidence. They don't step into the box, and there is no cross examination as such done, and it doesn't come forward as the rigors of your civil suit. So therefore, it's still a summary jurisprudence. Now, the law of the Supreme Court is that, of course, illegal repudiations, illegal rejection of claims, or will amount to deficiency in service, and it can be adjudicated before a consumer court. But when there are disputed or serious questions, as I gave you an example of quantum disputes, where you say that the surveyor has given 5 crores, you say you want 10 crores, those matters ideally are not suitable for a consumer commission, for the simple reason that there is a heavy duty casted on you to really lead evidence, to really disprove the report of the surveyor, and to really show that no, as per the contract of indemnity, I am entitled to this amount, and what I am claiming is not something out of by making it a windfall, but this is something which is actual loss suffered by me, and this is my actual entitlement. So the limitation that a commission really has is that it doesn't really adjudicate on very complex issues of facts. Of course, it's not a threshold like a writ petition, but it doesn't adjudicate on very complex issues of facts, and there are serious allegations involved. If there are allegations of fraud, etc., the appropriate remedy would be of a civil court. So when there are disputes on quantum, it is best avoided for parties to approach a consumer commission, because that commission in most cases has rejected matters by saying that you, by summarily pointing out that the surveyor or the company is wrong in calculating this depreciation or wrong in discarding this amount of process, why what is it that you are able to show, you are not able to show deficiency in service. So the consumer commission also comes with its own sets of limitations. The next being your most popular remedy today, which is used in course of all disputes, which is arbitration. Now, as good as it sounds, arbitration, why do then people go to civil courts at all, and why do people go to consumer courts also? Because you don't even have to wait in arbitration as much as you may have to wait in hierarchy in the consumer commission. Plus, you have an advantage that once your award is there, the company will not be able to challenge it on hyper technical grounds, and once the award is drawn in your favor, or of course against you, then you run the risk. But if the award is drawn in your favor, you really have a very narrow scope of interference in your section 34 petitions. Now, the reason why all disputes can't go before arbitration, all consumer disputes can't go before arbitration, is that first of all, of course, in health policies and life policies, there is no arbitration clause. There cannot be an arbitration clause in life policies, because the ultimate insured is not really going to survive the policy if the policy has to be triggered. Even in health policies, mediclaim policies, there are no arbitration clause set out. The second reason is that the arbitration clause is only found in general insurance policies. General insurance policies, of how I gave you an example of business houses. So those commercial risk policies, or those fire police policies, those industrial all risk policies, or your contractor all risk policies for creation of projects like your hydroelectric projects or creation of highways, etc., have insurance and have policies which have an arbitration clause. Now, why do then all matters not go for arbitration even in those? The simple reason is that the arbitration clause is worded in such a fashion that it carves out an exclusion of certain kinds of disputes. Now, what are those certain types of disputes? The clause is meant in clear terms to say, and it has been interpreted by the Supreme Court in a series of judgments, to say that only in cases where the company admits liability and the dispute is on quantum can the matter be referred to arbitration. Now, what does this mean? The first set of disputes, as I gave you an example of the company not admitting liability and saying there is a breach of a condition, breach of a warranty, and thereafter, on the basis of that, your claim itself is repudiated. There is nothing payable to you. You may have suffered loss of 50 crores, 100 crores, whatever may be the value, but there is absolutely nothing payable to you. This doesn't become a quantum dispute. Of course, there is a dispute on the monetary aspect of it, but it doesn't typically become a quantum dispute. It becomes a dispute of your repudiation. So, in those cases, there is no admission of liability. So when there is no admission of liability, the company, the arbitration clause itself, the dispute becomes non-arbitrable, because the arbitration clause excludes within its purview all matters where the liability has not been admitted. Now, this has gone on for years on end. It was earlier framed, the clause, why it was framed in this way, nobody really has any answer to that. But it was framed by the Tariff Advisory Committee years ago, and it continued across all insurance companies, whether private or public. And this was the clause that remained, and this was the clause which remained with the peculiarity. So the only dispute which was capable of being adjudicated in terms of arbitration was that there was a quantum dispute, liability was admitted, a simple dispute saying the insured is asking for 500 rupees and the company is paying you 100 rupees. So for the balance 400 rupees, you can come forward and come with a dispute. Now, that was something which was there in terms of arbitration. Now, the arbitration clause also in the year 2023 went in with some sort of a change. Now, what was that change? In Section 11 application filed before the Bombay High Court, after looking at the law then prevailing of Vidya Drolia, etc., the Bombay High Court said that all disputes as regards jurisdiction, etc., should be gone to the arbitrator, despite the Supreme Court earlier holding that in cases of this nature, in specific cases of these nature, like the insurance clause, where the clause is very clear in excluding disputes of repudiation, the High Court said that let the arbitrator be appointed, and let the dispute be relegated to arbitrator with a liberty to that party to really set out, raise their objections on jurisdiction before the arbitrator. Now, that was challenged by the insurance company by way of a special leave petition, and the Supreme Court really noticed the clause, not for the first time, it had noticed it on several occasions, and of course said that yes, the direction of the High Court is wrong. You, in these kind of clear cases, cannot relegate parties to arbitration. However, what the Supreme Court noticed is they issued notice to the IRDA, who was not a, which is the sector regulator, as I said, who was not a party to the proceedings, but they issued that notice to the IRDA and they said that why is there this kind of a peculiarity in your clause, and why is it that arbitrable? Like, of course, it's not something dispute. It is not something as a dispute which is per se not arbitrable in the eyes of law. You are not arbitrating a criminal dispute. You are not arbitrating which is a somewhere a dispute covered under the State Rent Act or something. So why is it that by virtue of this kind of a narrow clause you have made the dispute non-arbitrable? Why is it so? So the IRDA came up with a circular dated October 2023 and said that look, we've reviewed the matter basis the observations of the Supreme Court, and we feel that this should not be a cap. But what the IRDA in effect did was it really didn't change the arbitration clause, but it came up with a circular directing all companies and telling them that parties, basically the insured and the insurance company, may come up, and the words used were may come up with any arbitration clause to govern basically all disputes that may arise under them. Now, the good part of it is that the earlier cap of repudiation or that earlier sine qua non of admission of liability has gone away. But the end result is that the clause is not an arbitration clause if tested in light of various judgments of the Supreme Court and various high courts, because it is merely an enabling clause saying that the parties may decide to enter into a separate arbitration agreement. So, if at all at the time of issuance of the policies, the company doesn't enter into with you into a designated unequivocal arbitration agreement. The circular per se is not capable of any sort of an enforcement. So what has started happening after 2023 is that earlier the arbitration clauses came in the policies as a matter along with the generation of the policy itself. But in after 2023, the companies have simply not entered into an arbitration clause, and the insured at that point in time has not even realized that I am losing my right of arbitration because, as I said, standard form contract, and they take forward their policies. And in many of those policies, there is no arbitration clause itself. When the dispute takes place, they take recourse off to that circular, but eventually, to my knowledge, there is no definitive pronouncement on either side on this after the 2023 circular. But the court has what I understand it is as the court will not really be able to enforce the circular because the arbitration clause contained in the circular is a mere enabling clause, and it comes with nothing concrete. It only it gives liberty to both parties to enter into a separate arbitration agreement as they may. Now, in the absence of them entering into a separate arbitration agreement at all between the parties. So these were really the contours of what your dispute mechanism is there and how the dispute redressal takes place in the context of insurance. The other is going back to your principle of uberima fide as to of course, you will find a lot of literature and you will find a lot of cases where the company has filed claims against insured and said that you have suppressed your previous existing ailments and you have suppressed XYZ in the proposal form. The duty, which is often not very popularly, known, is that the same duty also applies to the insurer in that sense that the insurer at the time of entering into a contract with you is required you disclosure of all possible clauses. Now, what, as I said, that these clauses are standard form clauses, not even framed by companies in most cases, but framed by the IRDA or framed by the Tariff Advisory Committee. Now, they are clauses and they are standard settled terms worded for a particular policy, saying, for instance, that if you are having a polythene factory wherein your polythene is used, or if you are having a factory having rubber, there will be certain exclusions in which cases the company will not be liable. For instance, there has to be a specific fire safety mechanism if you are running a factory which is of hazardous goods, and that which will be of a higher threshold than what you would be required from a business house running mechanism of running a factory of say toys or of cloth. So in that cases, what happens is that many often the policy is generated. The policy doesn't come with the standard and settled clauses which are issued and framed by the Tariff Advisory Committee or by the IRDA. Ultimately, when a claim is lodged, the company takes a defense or repudiates the claim by saying that look, as per the tariff advisory committee, you were required to have this fire extinguishing mechanism in your company, which you did not have. To which the insured says that we were never put to notice that we were required to have all of this. The company then turns around and says that we are not the ones who have framed these policies, and these are framed by the tariff advisory committee or framed by the sector regulator, which is the IRDA, and they are in that sense mandatory. So courts have taken a view that even if framed by the sector regulator, even if framed by the tariff advisory committee, and even if mandatorily mandated by the authority, if the same is not disclosed to the insured, they will not be something which will be enforced in a court of law. In that sense, the defenses will not be available to the particular person or to the particular insurance company, saying in the absence of a non-disclosure of even terms and conditions which are otherwise capable of being included in the policy or otherwise deemed to be included in the policy, if there is a non-disclosure on those grounds, they cannot really be taken up. Now, only to sum up, before I sum up, I'll just tell you, when the matter goes to a court, what are the possible or the most how does one strategize litigation? So one is, of course, which I gave you an example of non-disclosure. In the absence of non-disclosure on the part of the insurance company, you cannot therefore be liable, or you cannot be blamed for not adhering to a particular term or a condition. The second is that the Supreme Court has also sort of narrowed down the scope of litigation by holding that grounds which are not taken in the repudiation letter cannot be taken by companies before a consumer commission. To give you a simple example, there are, say, 50 terms and conditions in a particular policy. The first term or condition says that your in case of you informing about the loss after a period of 7 days or after a period of 1 month, we will not be assuming risk of that claim. The second condition says that in the event of you storing goods within a particular sector in the absence of firefighting mechanism, we will not be liable. Now, both these grounds are ideally disclosed to you and are available with the insurance company for repudiating the claim. But in the repudiation letter, the company only takes one of those grounds. Later on, when the matter goes to court or goes to a consumer commission or goes to for adjudication, the company comes up and says, look, we have of course repudiated on the ground of breach of policy condition A, but there is also a breach of policy condition B, which is very evidently proved on record. So the courts have said that if you do not take a ground in the repudiation letter, even if there is a breach of a condition or a breach of a warranty, which is otherwise shown from the record of the case, the company cannot take it for the first time before the commission while the claim is for adjudication. So this gives an advantage to insureds, and in that sense, they are really required only to meet the grounds of repudiation when the matter actually goes for adjudication. So that was it by and large. I think ultimately, of course, the topic is very vast, and if we go into it and go into the nitty gritties of it, it will, I think, take up a lot of your time. So this was only to give you an overview of what the legal landscape is and how and what kind of disputes are really adjudicated. So thank you very much. If there are questions, please feel free to ask them.
So, is it compulsory to give the brief about the existing diseases while every time renewing the health
So
insurance?
that's something very interesting, and I think I wanted to touch upon it, but I couldn't on account of the time constraint. So what really happens is, while you enter into the contract for the first time, you will be required to sign a proposal form. Now, if later on at the next year you develop diabetes, you are on if that policy continues as in by way of a renewal, you are not required to again go to them and say that, look, now I've developed diabetes. Now you come forward and take a fresh proposal form. So what typically happens is that the proposal form is taken only once at the time when the policy comes into force for the first time. What happens thereafter is that there are renewals, and those renewals are based on the same terms and conditions. So the company cannot thereafter come forward and say that, look, we have unilaterally changed some terms and conditions and this will be a ground for repudiation. But ideally, to avoid litigation, if at all there are any comorbidities, or if at all there are some sort of some material change that has taken place at the site from the end of the insured, it's better to intimate them. But unless there is there, they cannot really call into question the policy on the ground of non-disclosure if it were all answers were honestly answered in the proposal form, and the proposal form is not taken at the time of renewal ever, because renewal enlists that the policy will continue on same terms and conditions.
And now, while switching from one company to another,
Right.
so that will
So,
be
so
considered
while
as a
switching from
renewal.
one company to another, if you look at the health insurance regulations of 2016, how this switching happens is enlisted in Schedule 1. Now, what it basically says is it is termed as something known as portability. So the onus and the responsibility is there on the ground, or it is there at the end of the insurance company to contact your previous insurer and say, look, this person was insured. Now, was this person having any comorbidities or whatever the previous claims made by this person with you? But they will also give you a proposal form at the time of shifting your policy. And the law is not very typically settled on this, because the non-disclosure in the proposal form gives the right to repudiation. However, on portability, it says that the obligation is on the insurer to take details from the earlier insurer. So I have a similar matter which was argued, I think, last Friday, and that is yet to be adjudicated. This similar issue came up wherein I was appearing for the insurance company, and we took up a ground saying that although we could not obtain any details from the earlier insurer, the insured still was under obligation to disclose it, since we had asked him in terms of the proposal form. So how I understand is that merely because there is a responsibility on the part of the insurer to look back from your earlier insurance company, it doesn't absolve the claimant or the insured from its obligation of disclosing all facts which are asked in the proposal form. If they are not asked, then there is absolutely nothing. But if they are asked, the same principle applies, that there has to be a honest disclosure of all things that are asked.
Okay, sir. Thank you.
Rishabh, one question in the chat box. If a person goes missing and has a life insurance, then when can the family claim?
So if he goes missing, so I'll tell you what. Now, if at all there is a life insurance policy, the obligations are that you are required to, of course, show the death of that particular person. Now, you will have to either prove with some concrete, reliable evidence that that person had died, or you will have to look at the statutory mandate of what law generally says, that a missing person beyond a particular years is presumed to be dead. So, in the absence of you proving death, or in the absence of you establishing death, you can't really make a claim under life insurance.
So the family has to wait for 7 years.
Ideally, if at all, he's completely gone missing.
Okay. The next
Yeah.
question is, many insurance companies discriminate against persons with disabilities by not covering them. What are the remedies under the constitution or any other law?
Right. So I'll not to tell you the regulations, etc., which are there, but there are initiatives taken by the government, and there are also regulations under the RPWD Act of 2016, which are framed from time to time, mandate companies from giving insurance. So of course, when we say that the company's choice is to give insurance or not, it's very easy. But for companies, giving particular sets of insurance becomes an obligation, and there are specific policies also framed wherein a person with XYZ disability is there. But now, what is the disability is something which is very widely seen. Now, a person with some disability from birth may be protected under the act and may be entitled to some sort of a beneficial insurance scheme that may be there, as a method of the government, or as a part of the government initiative. But a person, say, who meets with a road accident and thereafter has suffers loss of limb, etc., he, if as an individual goes to seek insurance, the premium amount that will be charged to him would be at a much higher rate. So once a person is categorized as a person with disability or a person with benchmark disability within the RPWD Act, there are government initiatives which I am not sure of offhand as to which are the regulations or which are the initiatives specifically in force. But there are initiatives which cast obligations on the companies to really give insurance to particular set of individuals.
Okay. The next question, can a criminal or a civil action be instituted against the agent for non disclosure or wrong disclosure of the policy?
So there are IRDA regulations which set out some regulations for the brokers, and they are popularly known as the brokers regulations. But if you ask me, typically the agent is required to be bound by what the other his master is telling him or instructing him. If you are able to establish that I told him to write XYZ, that I suffer from hypertension or I suffer from diabetes, and he wrote it on his own to sort of let the policy go through and thereafter earn some commission on it, thereafter then you can certainly sue him. But if at all you say that I am leaving it to the agent, and you don't provide any details to him, and you tell him that, look, you fill in whatever is there, I don't know anything, and you don't give him any instructions, then it's absolutely something where the insured itself is someone to be blamed. So it will depend on the facts, and for you to file institute any civil or criminal action, you'll have to establish that the agent didn't act, or he acted contrary to your instructions, or he didn't act within the framework of what is there in the agent's regulations. So if you are able to establish that, then you can initiate action.
Okay, the next question, any landmark judgments that you would recommend us to study?
So there are a list of them. I had of course given this judgment of Texaco marketing, etc., which is on the applicability of the exclusion clause. But there are a wide list of judgments. Offhand, I could tell you something like National Insurance versus Harsolia Motors. There is a judgment of the Supreme Court of Saurashtra Chemicals versus National Insurance Company, which deals with the grounds not taken in repudiation letter. There is also a very interesting judgment of the Supreme Court in the case of United India versus Canara Bank, which deals with what is an insurable interest, what is an effect of a blank in a proposal form. For health policies, there is that judgment of Rekhaben Rathod versus Reliance Insurance Company. There is also a judgment of Manmohan Nanda, authored by Justice Nagaratna, distinguishing Rekhaben Rathod, because Rekhaben Rathod was applied in such a way that on the ground of non-disclosure, claims were rejected all throughout and were even upheld by courts. So it casts an obligation, or it casts some sort of a burden on the company to prove certain facts, to really prove the ground of non-disclosure. That was also followed by Justice Nagaratna in another judgment of Mahakali Sujata versus Future Generali Insurance Company. So these are very popular judgments which are there. Then there is a judgment of Sikka papers, which deals with what is the effect given to a surveyor's report. So basis what you are required to do, what is the channel of litigation, there are a long spate of judgments, and these are offhand judgments which I could tell you which should be read, or which will give you an insight into what kind of disputes really come, and what are possible defenses, what are possible arguments, or what are how can you really build or set up your case.
One last question. So, in the event on the occurrence of an accident, what evidence should we gather so that our case becomes strong?
So, in the event of an accident, so this I believe is a question emanating from a motor insurance policy. In case you meet with an accident, what you are required to show is to the court, if you're making a claim against the person who's given you the impact, is the FIR and the police papers. They constitute to be the basic documents and basis that you can lodge your claim.
Thank you so much, Rishabh, for sharing your expertise and your knowledge on this topic. We are, I think, doing the first session on insurance claim
Right.
since the time we've started webinar. So, thank you so much for agreeing to cover this subject.
Thank you so much.